Good morning, sir. Are you Michael Barelick?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
And it's just the lesser Class A theft, correct?
Yes.
Mr. Barelick, in cause number 25, DCCR 0003, the state has elected to proceed on the lesser included offense of a Class A misdemeanor theft of property from June 24th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Barelick is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor theft of property. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. Good morning. You're Juan Sanchez?
Yes.
And Mr. Sanchez is on probation in cause number 1830854 for the offense of driving while intoxicated, third or more. Was previously in court, entered pleas of true to counts 1, 2, and 3 in that motion to revoke his probation. And there was an unagreed, there was no deal, and I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
And I have received some objections filed, comment and objections filed by Mr. Franklin. Mr. Nichols, does the state have any objections or corrections to the updated report?
Not to the report, Your Honor.
Okay. And so with regard to Mr. Franklin, specifically,
Dash.
with regard to number 1, that comment in there by the probation officer with regard to that it's unlikely that it was the first time, I'm not really going to take that into serious consideration. So that's not something that's going to make a big difference in what I do today or not do. So that one, I guess if it's an objection, that can be granted. With regard to number 2, which has to do with a note in the records that you were able to look at with Officer LeBlanc asking whether or not a naturalized citizen based on their criminal history could still be potentially denaturalized and deported, and that has some type of race bias. That is also not something that is going to impact my decision, I think, as far as what I'm going to do in the case. I understand your position. Honestly, with the criminal history, which I know is another objection, we'll get to that and what's going on. I don't think it's improper to ask those questions, and I don't see anything else, especially she even put some positive things that he's done in this updated report, so it's not all negative. So I don't think there's a clear sign that there's some kind of racial prejudice or anything like that. So that's overruled. With regard to the fact that his prior convictions are inadmissible hearsay and too remote, in any motion to revoke probation or any case, prior offenses could potentially not be admissible for purposes of enhancement or sentencing in front of a jury. But as far as going into, especially when it's a driving while intoxicated, which requires prior offenses to get where we are, I think it is imperative on me to understand the criminal history, understand when those were, understand the remoteness of some of these, but it doesn't take away from the fact that you have to have those prior driving while intoxicated to get where we are now. And so I'm going to overrule that objection with regard to the prior convictions. Any witnesses today by either party? Does anybody have any witnesses?
I have no additional witnesses, Your Honor.
Your Honor, we previously submitted letters of support.
Yes.
And we believe those are in the record, and the court has reviewed those. I
Yes.
just wanted to note, for purposes of today, that we have filed those. They have been reviewed by the court, and we hope the court has taken those into consideration in considering sentencing as well.
I will, and I did, and let me pull them up again just because I think that's been,
So specifically, they were not admitted for this purpose. They were admitted for bond.
okay, that's right, thank
For
you.
purposes of bond. However, the letters of support, the
same,
information in
sure.
them speak to my client's character and
Yes.
his support by the community.
I see them right here, and I did review them obviously for that, and we'll take them into consideration for this hearing as well.
Thank you, Your Honor.
Anything else?
Your Honor, just in response to the analysis of the court's overruling of the objection, we would point out, as noted in the PSR, there is a substantial time in between the prior conviction and the current one for which he's on
Sure.
probation. And we hope that the court was able to look at that and consider that from 2001 to 2018, there was
Yes.
a major gap. And then by all accounts, by the admission of the probation officer, Mr. Sanchez has had minimal violations, was not a supervision problem, made efforts to be in compliance with probation. And although he did plead true to the current violation, he has shown 5 years of continued compliance. And we ask that the court consider the gap in history, the 5 years of compliance, as factors to keep him on probation.
Thank you, Mr. Franklin. Mr. Nichols?
Your Honor, this case was originally pled as an 8-year cap. And I'd argued for Penn Diamond at its original sentencing 6 years ago. I'll acknowledge he's been mostly done well on probation except for the new offense and the new violations that are alleged that he did plead true to. And I agree that his criminal history, while somewhat extensive, is rather remote. So I think those factors give the court enough information to make a decision. I am in favor of revocation just because it is another DWI offense, Your Honor. But as far as the length of time, I think the court has enough information to make a just decision on that.
So, Mr. Sanchez, the issue, I understand Mr. Franklin's argument as well as Mr. Nichols. You did have a substantial amount of time where you were able to not drink and drive. The history is old, but then again, you started it up again, in my opinion. You got this DWI, so you had, there's a couple back in 1995, and then there's one in 2000, and then you had this one in 2018, and now we have another DWI that you have admitted to in another county where you were driving a vehicle without the interlock and under the influence. And at this point, I feel like we're all lucky that you have not, that we're here on a DWI, not an intox assault or an intox manslaughter or something like that. At some point, you've got to figure it out. You're on probation for the same offense. So I'm not inclined, and I don't think it's in the best interest of the community for you to remain on probation. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I am going to take some of the good things that you've done in the length of time into consideration. I had initially marked on this pre-sentence report that I should probably give you the full 10. Mr. Franklin makes some good arguments with regard to the length of time that you went without being in trouble. It looks like you did well with some things on probation, but the main thing, you didn't. And so at this time, I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you a trial court certification. I need y'all to sign this real quick, Mr. Franklin, that shows that this was not an agreement. So you do have some rights to appeal. Once y'all sign that, I'll tear off that bottom copy for y'all if y'all sign at the
Yes, sir.
bottom. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, then you can talk to Mr. Franklin. And I'm going to go back. I'm not sure if I'd said it exactly properly. I am going to reassess your punishment because you were already assessed a 10-year term. Reassess that punishment at 7 years. And here's that firearm, Mr. Franklin.
Thank you, Your Honor.
This is just going to go, this is to go in the pile after trial, yeah. Let's see. And the bottom 2 copies are y'all's if you want to tear those off.
Okay. I think you pressed very hard, Judge.
That's okay, as long as my signature came through, I'm okay, because I get the top 2 with his on it. Give me one more of those. There's 4.
I'm so sorry.
Nope, you're good. Perfect. Thank you. All right, sir, you can go back with the bailiff. Good morning, sir. You're Alfredo Gayton. And Mr. Gayton was previously in court in cause number 25 DCCR 0184. Entered a plea of guilty to driving while intoxicated third or more, which was enhanced to a second-degree felony because of prior offenses. The agreement was for a cap of 14 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Your Honor.
Are there any additions or corrections?
No, no more, Judge.
All right, Mr. Parker, you may proceed.
Just some of my client's knowledge, I've given the court and the prosecutor a letter of support from Frank Maida.
And I've received that and reviewed it as well.
And, Your Honor, from talking to this man, talking to people that have known him, he is a good person that's just an alcoholic. And I think he was, I think he was pretty honest in his PSI. He talks about drinking at the age of 11, then 14, and then get to the point where he drank, at least a 12-pack regularly. He drank tequila and Crown Royal regularly until the point where he passed out and could never get enough. He's had several DWIs in the past. He's never had any kind of help at all. And I think he is a prime candidate for safety to get the help. He's had some periods where he's tried to do it on his own, and he was somewhat successful. He cuts grass for a living for several people here in Beaumont. He has the ability to make money if he's given the opportunity to be put on probation and go to the safety program. So he can do that. It looks like to me that the PSI is also in concurrence that he would benefit from safety. And I just think that's the best thing for him instead of just locking him up.
Thank you, Mr. Parker. Ms. Malfino?
Judge, I think it goes without saying that he certainly could use the help of safety. I think it also has to go without saying that the criminal history that cannot be ignored. Obviously, of course, we'll defer to whatever the court deems appropriate. I respect Mr. Maida's letter. I take him at his word. But it's just difficult for me to argue both ways because I think he needs the help, but I also think we have the criminal history to take into consideration.
Right. And again, I think most of his criminal history is just drinking, and so many people have got the opportunity that's worked for him, and he, not from anybody's fault, he's never got that help, It's okay. Is there anything you want to tell the court?
I just, they sent me to prison and made me work and work and work. They never teach me has drinking and I always go for games. I'm always making is to trustee and I'm working on the freeways with Texas Department of Transportation, cleaning the roads, do anything. And disasters never give me a chance to stop.
But if you've gone to prison 3 prior times
Yes, ma'am.
for DWIs, 3 times you've gone to prison, so this is your 4th felony DWI.
Yes, ma'am.
This is your, at some point, when you get out of prison, do you say, I need help and I'm going to get help for myself, instead of saying somebody else didn't help me?
I never had a chance. I have to look for work and
But I know, but you have people like
yes,
Attorney Maida. You could have said, hey, I need some help. You know people that can help me. I don't want to go back to prison.
well, finally this time I end up on the right city with the right people. Create a really good reputation. I met Mr. Maida, Dr. Suri, and a lot of good people, and they check my background, and Mr. Maida said my wife and me discuss, and we willing to give an opportunity. I've been working for them for years now.
Yeah, I just to make more clarity, I think that when he came here and he was working for the people around here, there were some things that he was doing, and he was not drinking. I don't remember the incident, but there was an episode where he started drinking again, and it was pretty close to the time frame of this. I'm not saying this is the only time, but he had started drinking again. And I don't take it that he was blaming anybody for not giving him help. He just said he's never had that opportunity. And, when you're an alcoholic or a drug user or addicted to anything, it's easy for, to say, it's the same thing with an abused woman. Why don't you just leave? Why don't you just leave? Just learn.
But
Stop
if you-
drinking. And
but
it's hard, yeah.
I don't disagree that it's hard.
And
But I also, if you'd never been to prison before.
right.
And if you hadn't had the wake-up call of prison to say, I don't want to go back to prison, I need to figure out how to stop drinking. And then you get out and then you do it again. Well, I didn't figure that out. Let me go
Right.
do it again. Your blood alcohol was
0.257.
0.257. You ran off the road. You could have, there's just too many times that I see now, unfortunately, people in here where we're looking at someone who has killed someone or hurt someone, and the fact that this is your 7th DWI, it's your 7th. I don't disagree that you need help, but I don't feel like now's the time for, and I don't know what happened in those cases in Harris County and Bexar County. If you were given an opportunity, at some point, I feel like there's opportunities for probation where people decide not to do that because sometimes doing a few years in prison is easier.
Well, I think
It's
some of
odd to me that there has not been a probation.
I think some of these, he's sat in jail and wasn't able to bond out, and it's one of those deals, we'll plead you to 2 years or 4. I don't remember the numbers, and so.
You got 12 years back in 2004. 12 years for your DWI, 2nd felony DWI. Then you got another one after that, and for some reason, Bexar County said, well, let's give them less time. Let's give them 5. Let's reward them for continuing the wrong behavior. Anything else?
The same thing. I just see people that, it's, I concentrate solely on the fact that his criminal history is alcohol. And there are people that we've seen on their 4th or 5th that we've given safety to, or people that are on probation. People are on probation for DWI and they violate the terms of probation by drinking, and they come back before, all these courts, and several times we say, hey, let's give you safety, and I can make the same argument, you just went to court, I get it, but I don't get what people think. But I just think he's a prime candidate for safety, and he would benefit from it. He's a good person. He'll work. But I understand the court's position.
Yes, listen.
Yeah, sure.
I've been sober since the
I'm sorry.
I've been sober since the accident. I moved to a small shed.
You've been sober since the accident?
I moved to a shed that is on the back of the property, Mr. Maida, and he said one condition, no drinking. And I respect that, and I've been doing exactly what he says. Because I know he's the only one of the few persons that believe in me, and he's given me a great opportunity. I know it's the chase of my
I can't
life.
slow down.
He said he's one of the only ones that will give him an opportunity. He knows he's serious about it. He's allowed him to move on the back of his property in a little room, I think.
We even went to what they call a retreat. He asked me if we willing to go, and I said yes, sir. And we spent 3 days. And he's a great person. He's been helping me a lot.
So here's the thing. If I even were to consider, which I'm not sure why I'm even considering, but I might, giving you a probation, you would not drive ever a vehicle.
No, ma'am.
I mean, it would be part of your probation. So you're going to have to,
No, ma'am. I
ever.
haven't get a car.
Listen to her.
I mean, it would be a condition of your probation that you never drive the entire time that you're on my probation. You understand that?
Yes, ma'am.
So,
Judge, if it would help the court, I'd be happy to, trying to get with the probation department and get with those other district attorney's office and see if there's ever been a probation on any of those cases that have been subsequently been violated.
I think they typically are listed in here that way.
Yes.
And so it doesn't appear that there ever has been one. I guess one of my dilemmas now is if I do consider probation, it would have to be a straight probation and only for the 10. And I lose that opportunity that I have today to give up to 14
Well, you could
years.
one thing we could possibly do is sentence him to 10 over 10, give him 180 days up front and hold that in abeyance as a condition. I mean, which just extends it more. I mean,
Nah,
like a,
I don't know that it really extends the time. It just gives them time,
Right.
potentially.
yeah.
Okay, here's what I'm gonna do, Mr. Gayton. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to give you an opportunity today that you have not had, but there's going to be some conditions on this probation, and you will be on 0 tolerance. And what that means is that any violation, is going to get you right back in here with the sentence that I'm giving you today. I will make a notation. There will not be plea agreements on a motion to revoke your probation. If you violate, and I find that you violated, that's it. You're done. Do you understand?
Yes, ma'am.
So I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You're on probation for 10 years.
Yes, ma'am.
I'm going to order as a condition of your probation that you enter and successfully complete the safety program, and that when you're released as part of the aftercare, you will then enter and successfully complete the JCDI program, which is an outpatient program.
Yes, ma'am.
You will be ordered not to drive any vehicle ever whatsoever. You will also be ordered to wear at all times a scram device. That's a device that will tell me if you have alcohol in your system. If you test positive on that, when you get out after safety and you test positive for alcohol, you will immediately be back in here and go into prison for 10 years. It's that simple.
Yes, ma'am.
It's the length of time that you have been an alcoholic. This is going to be a very difficult process, but either you want to do it and go through that difficult process, or you want to spend the rest of your life in prison. So that's going to be up to you. There's no, I relapsed and this is a difficult thing, and I understand that. This is it. You will be ordered to serve 10 days upfront time as a condition of that program. That's required. You'll obviously get that time in while you're waiting to go to Safe P. Anything else condition-wise that anybody can think of? I'm sorry? I'm going to order a $500 fine. All right, so I think that covers it. And so, Mr. Gayton, I hope you take advantage of this. It sounds like you're ready finally at this point in your life. I hope you take advantage of it because, again, this is the only opportunity you're going to get here in this court.
Thank you, I appreciate everything.
A routine court session quickly turned into one of the most emotional hearings in Judge Raquel West's courtroom. First, a defendant accepted responsibility for theft and received a short jail sentence. Then came a repeat DUI offender hoping years of good behavior would save him, but the judge ruled that public safety came first, revoking his probation and sentencing him to 7 years in prison. Finally, another repeat offender stood before the court, admitting his lifelong struggle with alcohol. Instead of sending him straight back to prison, Judge West made a remarkable decision. She suspended a 10-year prison sentence and granted one final opportunity through strict probation with zero tolerance. Her warning was crystal clear. One mistake, one drink, or one violation would end that second chance forever. It was a powerful reminder that accountability and mercy can exist together, but only when someone is truly willing to change.